webinar today, Secure 2.0, What You Need to Know. And this is going to be a review of a new law that our experts will tell you about related to employee benefits and retirement plans. I'm going to briefly introduce our expert panelists today and then turn it over to them. Stay tuned for invites for upcoming webinars. We will be doing this on a monthly basis and should have an invite out shortly for June. In the meantime, I'm sure you'll enjoy this one. I'll start with Harry Atlas. Harry is one of our two panelists, and he's a partner in the Baltimore office here at Venable and has worked here as a Venable attorney for, I'll say, at least 22 years, because that's how long I've been here. And he's been here as long as I have, at least. And he is a partner in the employee benefits practice group, does a lot of work on retirement plan issues, executive compensation, other sorts of employee benefit plans, and also is very familiar with COBRA and HIPAA in the healthcare benefit space as well. Harry's been recognized by Chambers USA and is a graduate of University of Maryland School of Law. With Harry is Lisa Tavares, and Lisa has also been a great colleague and friend of mine here at Venable for a number of years, and does a lot of work, as does Harry, with nonprofit organization benefit plans. And many of you may be familiar with Harry and Lisa working with some of your 401k plans and other issues over the years. Lisa chairs the business division of the firm and is also a partner who does a lot of work on retirement and employee benefits plans. Before she came to Venable, Lisa was with the Office of Chief Counsel at the IRS and has been working here ever since leaving that role. And Lisa has been recognized in many different ways, and notably by the best lawyers in America in recent years. So we are in good hands with Lisa, who is a graduate of the Boston College School of Law and also has her LLM from Georgetown University. So I know you'll enjoy this, and I don't want to take any more time when we get into so we can let Lisa and Harry dive into the substance. So Lisa, I'll turn it over to you.
Great. Thank you. Good afternoon, everyone. Thank you for the kind introductions, George. I'm going to start by sharing what our agenda is for today. We've grouped the types of provisions related to Secure 2.0 that we're going to discuss into mandatory plan provisions, optional provisions, and administrative provisions. Then we'll talk about some other key provisions and based upon the timeline for the effective dates of those provisions, and try to walk you through what you need to be prepared for in upcoming years in order to comply with Secure 2.0, which was enacted December 29, 2022. Some provisions are effective upon enactment. Other provisions have delayed dates. So we'll go through that to some extent. The overall purpose and intent of the legislation was to increase opportunities for people to participate in employer-sponsored plans, to relieve some of the tax obligations in certain situations where there's no longer going to be a penalty, which we'll talk about, and to relieve some of the administrative burden on retirement plans. Although I think it's added a lot of burden in other ways, but these are the stated, articulated objectives of the legislation, and also to provide additional support and information to participants on retirement planning. So first, we're going to start with mandatory provisions.
Thank you, Lisa, and thank you, everybody, for joining us today. The first mandatory provision we're going to talk about is one which, from a plan sponsor's perspective, is probably going to be one of the easier ones, because this is actually largely managed by record keepers as opposed to plan sponsors, but that's not always true. So it's important to be aware of this. The people who have terminated employment and who have reached under current law age 72 are required to begin distributions over their life expectancy or a shorter period of time. This may sound familiar to you because in the original Secure Act from 2019, the age was raised from 70 and a half to 72. Secure 2.0 takes that a step further and beginning this year has raised that age to 73, and beginning 10 years from now has raised that age to 75. That these only apply to people who are not yet required to take distributions as of the time the change became effective. The Secure Act also modified the penalty for failing to take required minimum distributions. It for many years it's been 50% of the minimum distribution shortfall, which is very punitive. If somebody failed to take a minimum distribution, they would, between income taxes and the penalty, they would lose almost all of it unless they got the penalty waived. That penalty has been reduced to 25%, and it can be further reduced to 10% if things are corrected promptly. So that's a big relief for perhaps people who are older, people who may be ill, may not, for whatever reason, be able to take the distribution timely. This is a good provision.
Next, I'm going to talk about Roth catch-up contributions. I think this may be the number one change that's garnered a lot of conversation and that people are worried about. And I would say with good reason, because the effective date is January 1, 2024. And even if you have Roth in your plan, there's certain things that need to be put in place in order to comply with the law in that time frame. Specifically, the statute changed the current law to require that catch-up contributions for individuals who are 50 and over must now be made as Roth contributions if the individual has FICA wages in excess of $145,000 in the plan year. That $145,000 limit may sound close to a highly compensated employee limit, but it's tied to the FICA wages. So that might be that is another category that you'll need to keep track of. Obviously, it's being maintained in your payroll system, but for purposes of record keeping and 401k purposes, if you just had testing compensation and gross, we need to ensure that whatever definitions you're using, that FICA wages are appropriately defined and perhaps may require another column for you to keep track of. Individuals making less than $145,000 are able to elect to receive catch-up contributions, either pre-tax or Roth. And it'll be interesting to see how these administrative tasks are going to be handled. We were hoping that there would be some guidance from the IRS on these Roth catch-ups by now, because many employers are going to need to work with their own payroll system and then the record keepers. But what we, I think both Harry and I have experienced so far is that a lot of the burden is going to be on the employer itself and the payroll more than the record keeper. The record keeping systems are not lined up to manage whether it's the additional column that I talked about, but because of that tied to the FICA wages, there's going to need to be significant involvement by payroll. If a plan does not have a Roth contribution feature currently, then it will need to be added in order to make those catch-up contributions rather. And I would say if you don't currently have Roth, you should adopt that immediately. Record keepers have people in line to adopt adding those features. And as I understand it from a couple of record keepers, I mean, there's tens of thousands of plans that don't have those features. So you want to get in the queue to make that change even while we're waiting for guidance to clarify. And you want to start thinking about what needs to occur in your own payroll system, and start setting up meetings. At this point in the year, this legislation, as I mentioned, was effective in December 2022. We are now halfway through the year without specific guidance. Our recommendation, I think, generally to our clients at this point is we can't really wait for guidance much longer. If you have not talked to a payroll provider yet about what needs to be done, or you have proprietary payroll system that needs programming, our experience is it usually takes about 6 months to do certain programming, and ideally you would want to test these Roth contributions. It's unclear when the IRS is going to issue some guidance. They said they're working on it. And we'll just need to wait and see, but we're at the ready to help employers work through these issues, and we'd be happy to discuss them with you if it would be helpful.
I saw we just got a question, and we're not generally not taking questions, but I'll just reiterate the effective date for this is that Lisa just discussed is January 1st, 2024. What I'm about to talk about is another change to the catch-up rules that's effective 2025. And this is, if though that wasn't complicated enough, they're now an expansion of the catch-up limit for people who are ages 60 to 63 during the plan year, people who reach those ages during the plan year. Effective January 1st, 2025, instead of like today, we have a $7,500 catch-up. And in 2025, the catch-up is going to be for that group, for that subgroup, is going to be 150% of the limit. So, for example, if it were 7,500 as the base limit, the expanded limit would be $11,250. This is probably another programming challenge because you have to catch people as they age into this group and as they age out of the group. And the change that Lisa just discussed as far as Roth being catch-up being Roth only applies to these as well.
Oh, hold on, Harry.
The next, this is for plans that this affects, this is a very, I think, administratively complex provision. So increased access to retirement plans for part-time workers. So there's some distinction here between 401k and 403b plans. I know a lot of our audience has 403b plans, other 501c3 organizations. A lot of our audience also is 501c6 and other type of nonprofits and have 401k. So there's really two different tracks here. Although they're similar. Let's start with the 401k track. So 401k plans, there was a provision similar to this in the original Secure Act that said that anybody who has 500 or more hours of service in each of 3 consecutive 12-month measuring periods must be admitted to the 401k plan to make elective deferrals only. So you're probably familiar, there's long-standing rules that prior to the original Secure Act that the longest waiting period you could impose is a year of service. So this essentially cut that down for these so-called long-term part-time workers. That was secure. Original Secure Act said that for 401k plans, if you have 500 hours in each of 3 consecutive 12-month measuring periods, you have to admit the person for deferrals only. Secure 2.0 extends this requirement to 403b plans, and for both 401k and 403b plans, shortens that period so that the person only has to have 500 hours in each of 2 consecutive annual measuring periods. So as far as this, who does this apply to? This applies to your plan if there's an explicit part-time employee exclusion, it clearly applies. It also applies to plans that have a year of service requirement to make deferrals. In a 401k plan, that could be an explicit year of service. In a 403b plan, that could be a plan that's using the so-called not more than 20 hours of service per month exception to the general rule that you have to have universal availability. Another quirk here is that 403b plans that for educational institutions that exclude student employees, those who are more than half-time students and are exempt from FICA, the commentators are questioning whether this impacts those as well. So this could apply to a lot of plans. As we say here, we are waiting for IRS guidance on that latter point. And as far as the effective dates, it gets a little bit confusing. That's the final bullet point on the slide. The original Secure Act requirement becomes effective next year with a 3-year look-back period. So beginning in 2024, if you have a 401k plan, you have to look back 3 years, 21, 22, and 23 to see if anybody falls in this category. Beginning in 2025, the Secure Act 2-year requirement with the 2-year look back becomes effective and applies to both 401k and 403b plans.
All right, muted myself for fire engines. This is the last of the mandatory provisions before we move on to optional. So everything we've talked about so far is mandatory. The first is a requirement now for newly created plans, newly created 401k and 403b plans to automatically enroll participants. The minimum auto enroll percentage is 3%, up to 10%, but that 10% will be increased each year by 1%. The RMDs are no longer required on Roth accounts and employer-sponsored plans. So that's a good change. It makes sense because the whole idea of Roth is after tax. So we'll move to optional plan provisions next. And the first optional plan provision is an increase in the mandatory distribution threshold. Currently, plans may transfer retirement account balances from a plan to an auto rollover IRA if the balance is between $1,000 and $5,000 and the participant has not made a affirmative participant election with respect to the distribution of that money after they have left employment. This small cash out threshold has been changed from the top of it, the 5,000 number, to 7,000. So an employer can decide to change the cash out amount from 1,000 to 7,000 if the participant does not make an election and execute an automatic IRS rollover. This is an optional provision, as I said. I will note there's been some back and forth about whether or not this is optional, and there's been some confusing signaling from I think some government-related sources that the intent is for this to be adopted, but technically, based upon the statute, we think it's optional. And I'll say here, I think we've seen a couple of questions about slides. I believe they will be distributed, or they can be pushed out to you.
The next topic, again, optional, relates to so-called multiple employer and pooled employer 403b plans. This is another instance where Secure 2.0 is taking a concept from the original Secure Act that applied to 401k plans and extending it to 403b plans. For those who may not be familiar, a multiple employer or a pooled employer plan is a plan that is run by what we now call a pooled plan provider, typically a record keeper or financial institution. And what this is that instead of having your own plan for which you, the plan sponsor, are responsible for everything from top to bottom, instead of that model, under this model, you become a participating employer in a plan which is maintained by the pooled plan provider. So there's benefits to this that would include potential economies of scale, as far as pricing, potential having less in-house burden as far as administration of the plan. And the cons to this are that you're giving up control. You're giving up control over certainly some investment options. Those are going to be what they are. And also probably to some extent or another with respect to plan design. There's a number of technical provisions. We'll get into the technical provisions here, but the law creates this concept of a pooled plan provider. States that if one plan sponsor is non-compliant, that does not taint the whole plan, which has historically been an issue with these plans. And this is effective now. I will mention one thing, particular for 403b plans, is a lot of 403b plans have individually owned legacy annuity contracts. These are contracts, some of them have been around for 40 or 50 years, individually owned. It's not as easy for a 401k plan. It's relatively simple to transition to a pooled plan, to move the plan assets into the plan, and you're kind of done with your plan. For a 403b plan that has those legacy assets, it's not going to be that simple. So there are some quirks if you're a 403B plan sponsor and thinking about this, that should be considered. Also talk about 403B hardship withdrawals. Again, another instance of the legislation extending a 401k concept to 403B plans. Back in 2018, there was legislation that liberalized the hardship withdrawal rules for 401k plans in certain respects, as far as allowing withdrawals from different sources, contribution sources, including earnings on elective deferrals. This would the Secure 2.0 has a conforming change to the 403B hardship rule. So relatively minor change, but one which rationalizes and makes 403B the same as 401k.
The next provision that I'm going to talk about are student loan payments that are treated as elective deferrals and that the employer can make matches on. Student loan debt has been a hot topic for a number of years, and we know that some of the younger workers in the workforce are choosing between saving for retirement and repaying their loans. That results in low contribution rates in the plan, which later has an impact on people's retirement. A few years ago, there was a private letter ruling that allowed a particular employer to provide match on elective deferrals in the form of these student loan payments. And it became very popular and widely known. And the result here is now legislation after strong public interest. Secure 2.0 provides employers with the option to make the matching contribution based upon qualifying loan repayment for qualified higher education expenses. So it's not just any student loan repayment, and their definitions tied to what's actual qualifying loan repayments and higher education. The provision applies to 401k plans, 403b plans, and 457b plans. The matching contributions must be made at the same rate as the elective deferral contributions in the plan. So the student loan repayments are treated like elective deferrals, essentially for all purposes, and including the fact that those converted or considered elective deferral loan repayments are also subject to the annual deferral limits. So you have to keep track of what those amounts are. And for purposes of non-discrimination testing, plans are permitted to test separately the employees who are receiving the matching contributions on student loan payments to avoid unnecessary failure by plans by trying to do something for employees. Employers may rely upon the self-certification of an employee because they have to certify to the fact that they actually made these student loan payments. And if they are attesting to that on an annual basis, then you don't need to get further verification. The Department of Treasury is going to issue regulations, and we also are expecting that there will be a model amendment that's issued by the IRS whenever we get guidance. I don't know if that's going to be this year. The IRS has not given specific indication on a date for guidance. I saw some questions about specific questions, and with respect to most of what we've discussed today, the IRS or Department of Treasury are saying that there will be a grab bag of guidance, which means they'll put out a number of Q&As to specific questions, some similar to the things that I know that you have top of mind, while they're working on more substantial guidance. Ideally, we would get that in a few months, but right now we have very little guidance to answer specific questions, unfortunately. The next provision is withdrawal of emergency expenses. Under prior law, an additional 10% tax applied to early distributions from a 401k plan. Secure 2.0 provides an exception for $1,000 distribution if the distribution is for emergency expenses, which would be an an unforeseen or immediate financial need that arises for the person or someone in their family. The emergency distribution is limited to the vested benefit in the plan, so it can't be more than the account balance. If the account balance is less than $1,000, if it's $500, they could only get out that $500. It applies to all types, essentially, of defined contribution arrangements, 401A plans, which would include 401K plans, 403B plans, and 457B plans. The participant can actually repay the $1,000 within 3 years. And when it's recontributed, it's treated like it's an eligible rollover distribution. But they can only recontribute that $1,000 amount if they are eligible to make contributions. So if they've left employment, they wouldn't be able to recontribute the amount if they haven't taken a distribution of their account. And only one emergency distribution is allowed per year. The participant can't make further withdrawals during the 3-year window repayment without repaying the amount. So there's sort of two limits, one distribution per year, and then within that 3-year repayment window, they would have to repay in order to take another $1,000.
So that what Lisa talked about was one of the provisions in Secure 2.0 that's aimed at providing access to employees for their funds for emergencies. The other is a little bit more substantial, and it's this concept of a pension-linked emergency savings account. Kind of picture a separate little sidecar account. And again, this is optional. Both of these are optional. But if you choose to do this, you would have a separate sub-account for participants. And for non-highly compensated employees, they would be able to contribute up to $2,500 to this account. And that money would sit there and it would be available for emergencies, as broadly defined. The tax treatment of those would be Roth. It'd be like Roth. In other words, the money that went into that account would be taxed, subject to income tax when it went in, and the withdrawals would be completely tax-free. There would be no income tax even on the earnings, and no 10% penalty. The law allows employers to automatically enroll employees in this from up to 3% of compensation. I haven't seen anybody interested in doing that. That seems very complex, but there may be some out there who find that interesting. And these are also subject to match if you have a matching contribution. The reaction that I've gotten from most plan sponsors that I've talked to about this is it's a nice idea, but maybe a little bit too complicated to consider before there's more guidance and before all the mandatory changes are put into play. The next topic relates, we're back to Roth again. And I saw what somebody asked the question is whether are you required to have Roth contributions? The technical answer is no, you're not required to have Roth. The practical answer is, yeah, you kind of are, because as Lisa was talking about, if any of your highly paid people who are over that $145,000 threshold are not going to be able to do age 50 catch-up contributions at all starting next year if you don't have a Roth. So effectively, yes, effectively you do need to have a Roth. This and Congress, Congress likes Roth because it helps for the budgetary scoring of the legislation. That's why you see these provisions like the one I'm about to talk about, because when the legislation is scored, there's credit given for Roth because it accelerates the income tax. This next provision is in fact optional. The notion here, this is the first time, this is brand new concept, is that if a plan wants to, it can allow participants to designate employer contributions as Roth. So your matching contribution, your profit sharing contribution could be designated. You could allow participants to say, please make that on a Roth basis. Those would be subject to income tax. They would have to be vested when they're made. A lot of plans don't have, fully vested contributions, and there's questions about the tax withholding requirements for that. It's possible that the IRS will, in guidance, say that you don't have to do tax withholding. There's actually probably a decent chance that will be the case. But what I've seen, the way I've seen employers react to this is there's an existing provision of a law called an in-plan Roth conversion or in-plan Roth rollover, which says that if an employer this has been around for 10 plus years. If an employer wants to, it can allow employees to convert pre-tax contribution sources to Roth, and there's very specifically no withholding required if you do a conversion. I definitely have had a number of plan sponsor clients say, well, we're not going to go this far yet as far as this new concept, but we will consider adding the in-plan Roth conversion, or at least highlighting for people that that's available.
Secure 2.0 made rules that have come into play sort of one by one in different acts like CARES Act related to federal disasters now permanent, so that the IRS and Department of Treasury doesn't have to continue to issue special guidance each time that there's a federal disaster. The new provision allows distributions up to $22,000 to be distributed from employer plans. This is separate from any loan or other distribution you're trying to get. This is specifically tied to federally declared disasters. If your primary home is in a disaster area or you sustain economic loss by reason of a specific disaster, then you'll be eligible for this special $22,000 distribution. It's not clear, though, if the $22,000 is a lifetime limit, you can only sort of get this once, or if it can be used at different periods in time. Again, we are awaiting guidance from the IRS about the specifics of this rule. There's no 10% additional tax for an early distribution if you satisfy the requirements of being in a federally declared disaster zone. There's no mandatory 20% withholding on that distribution. And the distribution may be taken into tax over 3 years instead in the year in which you receive it. There's another interesting twist to this provision. If money was previously distributed to you to purchase a home, but because of the disaster, you can no longer use that money to purchase a home, you can recontribute that money under this provision to the plan within a specified period of time, which is essentially 6 months after. It was either after the law was enacted, so that will be running up in June, or after a specific disaster. This provision, similar to the provisions we saw with the CARES Act, allows loan relief. So it increases that loan limit to $100,000 or the greater of $10,000 or 100% of the account balance. And it covers technically all of the disasters going back to January 26, 2021. So there's, as I said, there have been separate releases of information over time. So it's trying to capture all those disasters. The next provision is a domestic abuse provision to address the fact that there may be individuals who are victims of domestic abuse and may not be able to easily get money from other assets that they have available, and they would be looking to the qualified plan. So it removes the 10% early withdrawal penalty. This is an optional provision. The employee self-certifies that they are a victim of domestic abuse. The distribution has to be made within 1 year of that domestic abuse. So we're basically taking people's word for the fact and their self-certification, which presumably a record keeper will have a form or something online that people would certify to. Presumably they would have to put in a date to satisfy that 1 year requirement. The participant can withdraw the lesser of $10,000 or 50% of the account balance. The $10,000 number for this particular provision will be indexed, meaning it will be increased beginning in 2025. So Like we see other limits, it may go up to $11,000 or $12,000 over time, but we don't know what the index amount will be. That's something you can expect to be added to the list that you see toward the end of the year, usually late October, early November, with limits. The participant for these domestic abuse distributions can repay that amount over 3 years. If it's repaid, the participants actually refunded income taxes. That's a little bit of an administrative hurdle. So this is something you'd have to work with record keepers on. And there would have to be clear communication to participants. And this applies to 403B plans, 401A plans, which include 401K plans, and 457B plans. So think of it as a provision that's similar to the qualified birth or adoption distributions.
Before I go on, just a housekeeping note, I wanted to announce the CLE code for today's program. It's Secure 2023, Secure 2023. The next provision is what this is really of interest to plan sponsors that have chronic low participation. For many years, there's been a rule that applied to both 401k plans and 403b plans, which is in IRS regulations, which says that you cannot offer employees anything, basically anything at all, to either participate or refrain from participating in a plan other than an employer match for a matching plan, and there's a couple of other narrow exceptions. The notion here is that the plan can offer de minimis financial incentives for contributing to a plan. Probably things like low dollar gift cards, maybe things like wellness credits under a wellness plan. There's no guidance yet. This was one of the many things that we need some guidance on to tell us what de minimis is. As far as this provision, there's really, I think nowadays a lot of people have automatic enrollment, which sort of takes care of this issue. Because if you have automatic enrollment, you're not likely to have low participation. But if for whatever reason, if you haven't gone to automatic enrollment, it may be something to think about. It's probably of more interest to 401k sponsors because the 401k plans have a so-called ADP non-discrimination test, and if there's low participation among people who are not highly compensated, that can reduce the amounts that highly compensated can contribute. That test does not apply to 403b plans, so it's probably less of an issue with 403b plans. But again, probably the best way to deal with this, unless there's a compelling reason not to, is to have automatic enrollment. All right, we're entering the section of our presentation we're referring to as administrative provisions. These are not substantive plan terms that change, but rather operational or administrative rules. This is a major change. We covered plan overpayments, and this relates to overpayments from all types of plans, 401A, 403B, governmental plans. And historically, if the plan made an overpayment, and when might an overpayment happen? It could happen under a defined benefit plan. Most employers don't have defined benefit plans, but some do. A defined benefit plan might have miscalculated somebody's benefit. It happens under a 401A, 401K, 403B plans if there was an overcontribution to somebody's account and that got distributed. For many years, there's been a notion that an employer has to try to get that money back, or at least has to ask for it back, with earnings. And according to the IRS correction procedures, has to tell the employee that excess is not eligible for IRA or plan rollover. So really kind of a messy process. And the Secure 2.0 really reverses that by 180 degrees. And again, we're talking about inadvertent or mistaken things. We're not talking about whether there's some form of wrongdoing or trickery or anything like that. But an honest mistake, you're no longer required to recoup. The employer is no longer is compelled to try to recoup it. There's no longer a need to say that excess amount is not eligible for rollover. If a fiduciary wants to pursue an overpayment, they generally can, but there's a number of restrictions, including that they cannot seek lost interest or earnings. The amount that they can recoup is just the principal amount of the excess that was distributed. That's a fairly major change. And they cannot seek it from a beneficiary, only from the participant themselves. And if you have periodic payments that have been going on for more than 3 years, there's limitations on the ability to recoup those. So if you happen to have an overpayment situation, be aware that there's really a sea change in how those are dealt with.
Next, we're going to talk about the IRS correction program. EPCRS stands for the Employee Plans Compliance Resolution System. The IRS has essentially an amnesty type program when there are errors that would put the tax qualified status of the plan at risk because the plan either failed to follow the terms of the plan or violated one of the tax rules in the day-to-day operation of the plan. Secure 2.0 makes very significant changes to the IRS correction program, but I would caution you that there is some dispute as to when this provision, which was presumably effective as of date of legislation by the statute, is actually effective. The IRS again here has to issue guidance. They are compelled to actually issue a new EPCRS. In the statute in Secure 2.0, additional errors can be self-corrected that don't exist under the current correction program. The EPCRS now applies to IRAs, just for your information. And it also extends the type of failures for required minimum distributions and allows the avoidance of certain excise tax, which are good and welcome features. The correction program has always had this concept of what is a insignificant or significant failure. Insignificant failures have been brought in to allow self-correction and over, I would say, the last 10 to 15 years. But what Secure 2.0 is doing is really broadening that. The statute now says that an eligible inadvertent failure can be corrected at any time. That's a failure that occurs even if the plan has practices and procedures in place, which is one of the criteria for actually being able to use self-correction. You're supposed to have practices and procedures in place, and this was just something unavoidable that happened. It can't be something that's egregious. It can't be something that's tax avoidance. But then I think there's still a gray area between the very dire misuse of plan assets versus just something that's happening in practice and procedures, where we know, at least on exam, the IRS in the past has not considered those to be insignificant failures. So as you're working through errors, it's important to work closely with a lawyer to make determinations about what is significant or insignificant, what's truly self-correctable. I would not suggest relying solely upon what the record keeper is advising you or believing that EPCRS just allows you to self-correct anything now. I was at a meeting with IRS officials last week with them speaking on a non-binding basis. They were clear, though, that this is just not broad self-correction. So the statute also eliminates the time frame that we've generally looked at is 3 years for you to correct errors. And it seemed from the statute that it provided an indefinite period of time. But again, based upon comments from people from the IRS and the fact that the legislation doesn't wipe out EPCRS, it says that the IRS has the ability to issue guidance. We should be very careful in assuming that a time frame is just open in terms of correction, and that's something that's available for self-correction. Keep in mind that if the IRS finds the failure before you have started self-correction, that it's no longer eligible for self-correction, and it would no longer be eligible for what we call audit cap. If you get audited tomorrow, there was an error that's either identified by the IRS or you've identified an error but haven't done anything to self-correct that error yet, they're going to treat it as a full error. You're not going to get any benefit or reduction on the fee or sanction that's imposed to correct that error. Self-correction must be made within a reasonable time. Again, the statute didn't define what reasonable time is. So it's important to work closely with the lawyer to try to interpret these terms and figure out what's reasonable under the statute and based upon the limited guidance that we have now. The good news is that there's an opportunity to correct plan loans here that's been greater than it's been before. They have been allowing in each iteration of the EPCRS more plan loan correction without having to go in. And now there is relief under the legislation for inadvertent plan loan failures. One of the favorable aspects of the loan relief also is the fact that if you follow the requirements of the statute, that you are now automatically satisfying the DOL, Voluntary Fiduciary Correction Program requirements. You would no longer have to go in to get a no action letter. And oftentimes plan sponsors are weighing, well, I'm going to do IRS correction. Why should I have to separately go into DOL? It is possible, though, I would note the DOL may put into place, they have the authority under the statute to have some sort of reporting requirement. We'll see whether that happens or not. They have plenty of other things to do under the Act. One specific error I wanted to mention is errors in implementing automatic enrollment or auto escalation. In the, I think, last 5 to 7 years, they've been correctable under a safe harbor, which was put out in guidance. And then it was incorporated into the last version of EPCRS. There's now a statutory provision which confirms that these, again, they're seemingly inadvertent failures. The failure to enroll someone on time can be corrected or self-corrected. The contributions under the safe harbor are tied to being fixed within a 9.5-month period after the end of the plan year. And the employer must still make up missed matching contributions. So even though this had been adopted in EPCRS, it took so long for some of this legislation to come out. This provision got incorporated into Secure 2.0. I mentioned earlier there's this 2-year period for EPCRS guidance to be issued. The IRS has indicated informally that they hope to get guidance out in advance of those 2 years, and in particular are looking for comments from the public on correction.
As far as self-certification of hardship withdrawal eligibility, Secure 2.0 allows participants to self-certify that they're eligible for a hardship withdrawal. Previously, a participant who had a hardship event such as education expense, medical expense, certain casualty expenses would have had to provide documentation of that. And Secure 2.0 specifically says now that that documentation is not required. I've had mixed reaction to this from plan sponsors. On the face of it, it sounds like a great thing, less documents are better. The reality, though, is that most of this is handled by record keepers, so plan sponsors really don't spend time with this. And I've had more than one plan sponsor say, we're really not comfortable allowing people to self-certify for these, because unlike some of the other in-service distributions we've talked about, these can really be potentially very large amounts. So I think it's a decision from a plan sponsor's perspective whether to require documentation. And of course, we need to find out what your record keeper is willing to do. If your record keeper is not willing to require documentation anymore, then that's not going to be an option. So that's a little bit more here to think about than it appears on the face of it. Another provision of Secure 2.0 this is intended to cut down on the administrative burden of sending out notices, annual notices to people who are not enrolled. Think of things like a qualified default investment arrangement notice, things like that, that you routinely send out to all your people. But some employers, it's not a big deal if your entire workforce sits at a computer all day. It's easy to distribute the stuff electronically, not a big deal. But a lot of our clients, not the case. They have people either on a work site, not sitting behind a desk. Those people have to get mailings, and when you start doing mailings, they're expensive and time consuming. So the idea here is that if somebody is unenrolled, has either not met the eligibility requirements or has chosen not to participate, you have to give them a notice at each year reminding them of their eligibility. You have to give them a summary plan description when they become eligible. If they ask you for anything, you got to give it to them if it's required by law. But you don't have to proactively send out notices that are inapplicable for people who've chosen not to participate. This again is going to be something where the guidance is going to be important to understand exactly which notices it does and does not apply to. This is effective beginning next year.
Next are plan amendment deadlines. So we talked about a lot of changes. We're going to run through the effective dates in a few minutes of various changes that we put into a chart for you. But the deadline for plan amendments for Secure 2.0 is the last day of the 2025 plan year. So for calendar year plans, that's December 31st, 2025. The plan amendment deadline now matches up with the Secure 1.0, I guess, the original Secure Act and the CARES Act. So they've tried to simplify it, but that also puts a lot of pressure on the fact that we keep saying we don't have any guidance. We're still looking for guidance on those other statutes in some instances. As you've heard today, some of these provisions are carryovers or expansions of provisions in the original Secure Act or in the CARES Act. But we do think that the deadline should be kept in mind. In operation, you will be doing things, but we don't have guidance. We don't have model amendments yet for what is supposed to be done. So you need to be careful to document the processes and the procedures you put in place if your plan administrative manuals are being updated by record keepers. If you're using prototype documents from the various record keepers, presumably they will be updating on the timeline for those prototypes. But for individually designed plans, the deadline is that December 31st, 2025 date. And we would expect that record keepers would start doing what we generally refer to as snap-on amendments within 6 to 8 months after we get some guidance on these issues, where they will have you start electing, like they've done for CARES Act and Secure, which provisions you would like to adopt. And then they would have more sort of fulsome amendments that would have the required language that's necessary for the plan to maintain its tax qualified status. Next are just a summary of the key provisions. And we've gone by effective date, and we've listed which are optional, which are mandatory based upon the effective date here. And I think, as we talked about before, Roth contributions are the big issue for these effective dates. And so I don't think we can try to answer some questions, but we'll let you look at these. Here, I don't know if you want to run through anything here. Do we want to try to
answer some questions?
a couple questions, but we're hoping that this chart will be an easy reference guide for each of you to use to try to keep track of what's optional and when the effective dates are. I would keep eyes out for an alert from us. When we do get some guidance from the IRS, we will put out something that outlines and summarizes what they put out.
Sure, we could take some of these questions. Looks like there's a lot of questions on the Roth. What are the chances that the Roth catch-up provision will be delayed? Probably zero, because it's hardwired in legislation. How do you manage the $145,000 compensation limit for an employee who's a new hire? Basically get a free pass for the year of hire, because it looks at compensation from the previous year, from that specific employer group, controlled group.
What else do we have here?
A couple of these.
And employers require that all catch-up contributions be Roth regardless of employees' compensation. Well, to be clear, we don't have specific answers on any of these because we don't have guidance. I would think, I don't see anything in the statute that would prohibit an employer from requiring all catch-ups to be Roth, but as a practical matter, I think that might be a high hurdle with your participants. People generally, I think, are in the category of they understand and they're interested in Roth, or they're very scared of it. And so that would be, I think, just something to think about. And Roth generally requires, some education for people to understand.
Yeah, no, absolutely. One question about the 145,000 is based on prior year compensation, not the, so when the year starts, you look back at the prior year at FICA wages.
Mm-hmm.
And the question was, the 60 to 63 mandatory or optional? I think you may be able to say, technically maybe it's optional, but not really. I mean, that's the way record keepers are going to be built. But again, I think we wait for guidance and see if the IRS specifically says it's optional. Maybe people will choose not to
Right,
do
but on a reading of the statute, the way we broke these out is the statute, I believe, says shall, and that's the
it says it shall increase.
shall or may. So
Yeah, shall increase. So yeah, I guess you could, right. These are all good questions.
we're just looking through. Oh, the overpayment. Did you see this last one?
Yeah, how does the recovery of an overpayment apply to a participant who's passed away? Can it be recovered? That's a good question. You can't recover it from a beneficiary, but that's a different question. Somebody's asking about recovering it from, I guess, from the estate of a deceased participant. I don't know.
I think we viewed in the past, before this enactment of Secure 2.0, is that you did have to go against the estate.
Yeah.
And as Harry said, I think there's still there's some hurdles that the plan sponsor would have to go through if you wanted to go to that extent. But I think this is a welcome relief to plan sponsors, that they wouldn't have to go after assets to a deceased employee if you were inclined to let that go. I think you don't have to worry about the fiduciary provisions anymore and being in violation of the fiduciary requirements or the IRS correction requirements that also require you to recover money that's related to some operational failure.
Somebody's asked about catch-up contributions for people over 63. When you get to somebody who turns 64 or a higher age in a year, they're back to the general catch-up limit. If we were talking about this year, it'd be 7,500. When this provision is effective, it'll be something higher than that because of inflation adjustments.
Okay, well, I think we can give, hold on, I have the CLE code to give again. Secure 2023 is the CLE code. Thank you for joining us. As I said earlier, we will put out some summary of guidance when it comes out. Again, I think Harry and I would both encourage you to work closely with counsel on implementation of Roth, as well as other provisions, because there are a number of things that need to be considered. Roth is probably sort of top of our list. And also with respect to any corrections that you're making, we know people widely utilize self-correction, but you should consider the fact that the IRS, we believe, still has some ability to limit or more specifically prescribe what is self-correctable. And so you should work with lawyers to help you discern what's appropriate, and what you can rely upon in the event of audit is providing protection and mitigate any penalties that the IRS may try to assess. Thank you for joining us.
Thank you for taking the time.